Hello everyone. Today we are going to present IP in agriculture, and my teammates are Antu, Laura, and Omaima. First of all, we will start with the role of IP in agriculture and why do we need intellectual property rights in agriculture. So the first and foremost, the main reason is to encourage innovation. Innovation is needed to meet the challenges of a rapidly growing population, which is estimated to increase from 7 billion today to almost 9 billion by 2050, which also means that there will be a higher demand for agricultural production. It requires to increase by 70% by 2050. And the climate change and decreasing availability of water and farmland will add further complexity to the current situation. Therefore, to solve this issue, it should be produced more with less land, fewer inputs, including less fertilizer, which can only be done if agricultural innovation is maximized in the areas of seeds, biotechnology, crop protection, resource-saving agricultural practices, storage, and transportation. So without IPRs, there is a little incentive to innovate, as there are no means to get a return on innovation. What is the innovation in agriculture? Agricultural innovation is the process whereby individuals or organizations bring new or existing products, processes, or ways of organization into use for the first time in a specific context in order to increase effectiveness, competitiveness, and resilience to shocks or environmental sustainability, and thereby contribute to food security and nutrition, economic development, or sustainable natural resource management. So there are many innovations in the agricultural sector, which are mainly process innovations that relate to production techniques. For example, adoption of improved seeds, irrigation and waste management technologies, and the development by farmers of practices adapted to their situation. So as you can see in the pictures, the Internet of Things in agriculture as a fourth agricultural revolution is showing its effects. However, there are some shortages in skills which should be in the future worked and to improve the agricultural sector. So IP protection for the agricultural innovations has helped to increase circulation of knowledge through transfer techniques, transfer of designs, trademarks, and other IP protected assets.
In this part, we're gonna present 5 well-known examples of intellectual property rights protected innovations in agriculture. The first one is the first patent that was granted in 1886 in mechanization by the creation of tractors that are one of the great labor-saving innovations of the 20th century. Then in 1911, the first patent for synthetic fertilizer was granted. And we have to mention here that synthetic fertilizer supplies are essential for the growth of plants. Thirdly, in the crop protection area, the first fungicide patent was granted in 1934, and such products protect crops against diseases, insects, and weeds. Then the revolutionary drip irrigation method that was patented in 1963. This method provides water directly to the roots of a plant through a tube system. It has been used on more than 6 million hectares around the globe. Finally, in 1992, the first plant biotechnology patent was granted. In this part, we can conclude that the innovative core that have been adopted until now in the field of agriculture helps to transform farming and plays an important role in the long-term productivity and sustainability in agriculture. It also increases the global income. For example, the biotech core had added 75 billion euros to global farm incomes. And we can say that the plant science industry is one of the most research and development intensive industries. It ranks in the top 5 global industries in terms of percentage of revenue invested into research and development. For example, the industry's top 10 companies invest annually about 1.69 billion euros into new product development. So the cost of discovery, development, and authorization of a new plant biotech type is estimated at over 100 million euros. While we can say that the agriculture innovation has really improved, especially that we noticed that in the history the most agriculture research was founded from public sources. But since 1992, when the first biotechnology patent was granted, the private sector became more dominant. This means that the ability to protect intellectual property rights has increased the ability of technology developers to recover their investments and generate more profit. So, the protection of agricultural property rights stimulated private sector investment toward more agricultural innovations.
Will IPRs have positive or negative impact on agricultural sector? So the positive impacts. Effective IP protection system will provide an incentive to stimulate new and more effective breeding work at the domestic level. IPRs systems can provide important benefits by removing barriers to trade. It will improve production and exports. They are important means of technology transfer and effective utilization of genetic resources and a means to achieve higher yields and economic benefits. IPRs are also an important mechanism to recoup the substantial costs of research and development in agriculture because plant science companies they invest about 15% of their turnover into seed-related research, which approximately takes 8 to 15 years before it's viable. So therefore, the companies to take their returns back and attract more investors, they need IP rights. And what are the negative impacts? They are that the domestic industries of developing countries will be negatively affected from the monopoly power of IPRs, which may deter local innovation, productivity, technology transfer, and trade. And also IP rights in agricultural technology are pushing up prices and enabling agricultural innovators to generate huge profits at the expense of farmers and the public. How IP rights in agricultural sector came into existence. So before, historically, IPRs and plant breeding have had nothing to do with each other. Patents were never allowed on life forms because of ethics, colonial legacies, and the threat that monopolies in the health and food sectors pose to people's basic needs. Industrialized countries also excluded living organisms from intellectual property regimes. Unlike manufactured products, biological material was considered the realm of nature and therefore regarded as a discovery, not an invention. But with the dawn of the hybrid seed industry and later the biotechnology-driven life sciences industry, plant breeding has become big business, and those businesses want exclusive rights to their research results, as I mentioned earlier, because it takes a lot of money and time. By the mid-1990s, some industrialized countries began to offer limited forms of plant variety protection to breeders of new crop varieties. PVP was constructed as so-called alternative to patenting that would supposedly be attuned to the needs of agriculture. What is the new plant variety? We know that the plant kingdom is very big and has been classified into divisions and subdivisions. The division, which is most familiar to us, is the species. Plants of different species such as rose, potato, wheat, and apple cannot interbreed by natural means. Therefore, farmers and growers use a more precisely defined group of plants selected from within a species, which is called a plant variety. A plant variety is defined by Article 1 of the UPOV Convention as a plant grouping within a single botanical taxon of the lowest known rank, which grouping, irrespective of whether the conditions for the grant of a breeder's right are fully met. So this all confirms that a plant variety results from the lowest subdivision of the species, and that variety must be recognizable by its characteristic, which must be recognizably different from any other variety and remain unchanged through the process of propagation. Here is my last slide, the foundations of intellectual property rights. A number of arguments based on natural justice or morality have been articulated to promote an expansion of IPRs in agriculture and other areas. The granting of IPRs has been historically justified on three different types of grounds: natural rights-based proprietarianism, distributive justice, and instrumentalism. So the first approach is about that it gives property interests moral primacy, which means that the person who is first connected to an object with economic value is entitled to appropriate it. The second, IPRs, namely patents, have been regarded by some as a reward that the society is morally obligated to give to whoever introduces a new creation or invention. And the last, instrumentalism, this approach conceives IPRs as a tool that society creates to attain objectives of its own choice. Under this conception, knowledge is by its very nature a public good, and IPRs withhold the use of information from the common pool for practical reasons, not as recognition of pre-existing rights or as a morally due reward. So if instrumentalism was properly applied, then countries would allow to design their IPR policies in accordance with their own conditions and objectives, including in the area of agriculture. However, in the last 25-30 years, a proprietarian approach influenced the national legislation and case laws. So some of the best examples of proprietarianism may be found in the area of IPRs applied to plants, animals, microbiological organisms, and their parts and components such as cells and genes. Thank you for your attention. This is the end of my part, and Antu will continue with the legal frames.
Okay, so welcome to my presentation, which is a legal framework for IPRs in agriculture. I know this one is not interesting, so I will try to make it short and less boring as much as I can. So here the presentation flow, I have three main parts, which are an overview and IPR legal systems at international level and at the regional and national level. I would bring some examples about the USA, the EU, and some Asian countries. To begin with, I want to give you an overall picture of IP protection in agriculture from legislative approach. IPR's legislation framework in agriculture has been developed in the last 60 years in an attempt to realize the patentability of living organisms, including microbes, plants, animals, and their parts and components. Everything started with the U.S. Supreme Court decision in Diamond and Chakrabarti. And nowadays there are three most widely known international treaty system agreements concerning IPRs in agriculture, which are the UPOV Act, the TRIPS Agreement, and finally the Farmers' Right. There are different forms, other forms of IP protection in agriculture, like trademarks, marks used in commerce, geographical indication, trade secret protection. But my presentation today will focus on the plant varieties patents and plant breeders' rights. I made a graph to illustrate the relationship between three different international legal framework for agriculture. So let's take a deeper look at the legal system at international level. I will start with UPOV Act, which stands for the International Union for the Protection of New Varieties of Plants. The first UPOV Act was drafted in 1961, and after that there are three different versions. There is 72 version, 78, and the 91 version. They are still valid until today, which means that a country can choose to follow one of the three acts. Why it is important? Because it was the first attempt to protect plant breeders on a global scale, or in other words, it laid out the foundation for further legal framework to protect plants variety. The listed data I got from the internet as of the 3rd of February, there are 76 members have been parties to the UPOV Act. Basically, the UPOV Act covers the most of the international IPR obligation, but they did not mention anything about the MFN treatments, the most favored nation. I think it's one of the weaknesses of the UPOV Act. For your better understanding, I tried to create a table to compare the differences between the 78 and the 91 version of the UPOV Act. Here I wanted to highlight the difference between the minimum scope of coverage, which for the first one, the first version, it was 24 years, but the second one is only 10 years. And next, let's move to the TRIPS agreement. I think most of you are more familiar with this one. So here there's some basic slides, some basic information about TRIPS. It was adopted in 1994. It was created by the WTO, World Trade Organization, established universal minimum standards for protection in agriculture. But there's one argument about the TRIPS agreements, because it only devotes only minimal attention to plant breeders' rights and plant variety protection, and it doesn't even mention about the UPOV Act. But it's still worth to mention because it encourages the legal protection. Like, it's proof that a lot of nations in the world had stand together to protect plant variety. Like before this one, like no countries even mention or talk about the protection of IPR in agriculture, about plants, about animals. For more detailed information, you guys can download the PDF version of TRIPS agreement available on the website of the WCAG. Here I will make some short summarize. The members of the World Trade Organization, they can protect the plant's varieties using one of three distinct approaches. One is the patent law, the second one is the ineffective sui generis, and finally is the combination of the first and the second one. You can find its information in the article 27.3 in the TRIPS agreement. So what does this mean? So patent laws, I think like you already understand about this one, but basically like members, they are free to choose one legal system that they would adopt within their countries, but of course there are some requirements that they have to meet. I will mention right after this slide. Nowadays there are several TRIPS plus treaties that go beyond the minimum level of IPRs in agricultures. In TRIPS, like the US Free Trade Agreement with Central America, US, Chile, Euro, Mediterranean, etc. I think I will skip the patent law part because it's too obvious. But for the effective sui generis, I think it's new to some of you, so I would explain more about this one. What does this mean? It's a Latin word. It means that of its own kind or unique. So a country can create their own legal framework for plant variety system. But of course, it had to comply with the core requirements and objective of the TRIPS agreement. They will create their own legal system and then send their proposal, submit it to the World Trade Organization, waiting for their evaluation, and then waiting for their acceptance. Here's another table. I try to compare the differences between plant variety protection under UPOV Act and the TRIPS patent laws. Here I want to focus on the minimum term of protection. For the TRIPS, I think there's only one number. It's 20 years from the date of the patent application field. So I think it's more precise and unified compared to the UPOV Act, which is ranging from 15 years to 25 years. And finally, the farmer's right. Why I want to mention about this one, because it's like a counter challenge to the IPR concerned the relationship between farmers' rights and IPR in plant varieties. Because it had to harmonize the rights of farmer, the development of agriculture as well. And also there's another documents another legal system regarding agricultures in IPR in agricultures, like the Convention of Biological Diversity, but because of the time limit I will not mention that one. So how about the regional and national level? I will start with talking the USA. They are like always like the leader in this field, because in 1930 they already have the Plant Patent Act, and 40 years later they have the Plant Variety Protection. And USA also like the countries where everything begins. How about the EU? Like under this, at the EU level, there are two coexistent systems for IPR protection in agriculturals. One is the Community Plant Variety Rights System, CPVR system, or the regional system. The second one is the national system, the PVP system. So these two systems, they coexist with each other, but they prohibited for the dual protection, which means that you cannot apply for protection at the both office. And for the CPVR system, they have an official office to deal with the problem concerning IPR, such as the dispute, disagreement. And here I want to highlight the date, the term of minimum protections for the PVR, which is the national system. It's 20 years, but for the CPVR system, it's longer, it's 30 years. Here are the main steps in applying for CPVR. So overall, there are 5 steps. Started with filling the application, waiting for the examination, technical and the formal examination like the novelty, the credential, the entitlement, and then waiting for the examination of the suitability, and finally you will be granted for the PVP by the CPVO. So how about Asian countries? What is so important to mention about Asian countries in terms of IPRs in agriculture? Because for many Asian countries, agriculture still accounts for more than half of their GDP. The dominance in agriculture makes it really difficult for them to protect their agriculture industry, the rights of their farmers, while respecting and following the strict rules or regulation of the TRIPS or UPOV. So some countries like India or Bangladesh or Pakistan, they came up with the idea that they have a twin system to protect the plant varieties and farmer rights, but their development created favorable legal condition for international partnership in biotechnology, but they will at the same time will engage in and benefit the rights of their farmers.
Now I'm going to talk about IP in agriculture in developed and developing countries, starting with developed countries. In this part, we are going to talk about the history and a short history and description about the IP in agriculture. And the pressures from the USA and Europe have resulted in the proliferation of a stronger intellectual property protection worldwide as a condition of continued access to the world. In the past quarter century, the revolution in IP protections has radically altered the set of opportunities for financing and encouraging innovations in crop breeding and related areas. This history consists predominantly of developed countries' experience, with USA as a leader of the dominant player. Most countries have been committed by multilateral and bilateral international agreement to adopt stronger IP protection. Applications of agricultural biotechnology offer then great potential benefits, but also pose significant policy challenges. Regarding revolution in IP protection in agriculture for developed countries, we start with plant patents. USA, via the Plant Patent Act of 1930, was the first country to offer IP protection especially directed at plants. Legible plants were asexually propagated plants other than tubers. This type of protection have been important in horticulture and in particular for protecting barriers, vines, fruit trees, and ornamentals. Plants variety protections. In 1917, protection was extended to sexually reproduced varieties in the USA via the Plants Variety Protection Act. Plant varieties that were new, distinct, uniform, and stable become eligible for plant variety protection certificates and allowed to trade. A similar protection of plant breeders' rights has been in Europe in the form of plant variety protection. Regarding to utility patents, what is beyond doubt is that there is no consensus among economists regarding the global merits of the King of Training of Patents Protection, implemented by the USA since 1980, comparable consensus of the global merits of freer trade. Nevertheless, other developed countries have followed to varying degrees. USA lead in strengthening in IP protection. The global proliferation of intellectual property protections in developed countries, the degree of patent protection available to plants and animals per se and other life forms varies from country to country and is usually less strong than the USA. Though patent protection is strictly national in scope, international treaties and conventions govern various aspects of patenting. The WIPO has a lead role in coordination and information collections. It offers an important service in assisting developing countries with implementation of patent systems. Now I'm going to talk about the developing countries in in agriculture. Patents, plant breeders' rights, and trademarks are awarded by national governments, and the protection is valid only in countries in which they are issued. Thus, to obtain protection in several countries, rights must be applied for the award in each. At present, many key technologies used in the development of agribiotech products appear to be unprotected in developing countries. For example, patents for the most widely used promoter, the CAMB 35S promoter, have been granted only in USA and Europe. Thus, there is no IP restrictions in developing countries on the use of this tool in research and development at present. Furthermore, anyone is free to use technologies in crops that are developed, produced, and consumed in countries where the technology is not subject to local IP protection. Intellectual property rights and trade barriers. A large part of the population in developing countries depend on the production and sale of agricultural products. Agriculture is called to play a central role in achieving the Millennium Development Goal of halving extreme poverty and hunger. The expansion of agricultural support may contribute if appropriate income distribution policies are in place to reduce poverty and global income inequalities. Now, the comparison between developed and developing countries in the application of IP agriculture. As you can see, developed countries started decades ago for the process of innovation and patents for some plant species and other areas in agriculture like biotechnology, and also its leadership in development and innovation in technologies for agriculture, plants, and food. In the case of developing countries, they depend in high level on agriculture produce. The economy in general depends on agricultural products, and many of these countries have lacked in innovation and infrastructure for plants and biotechnology.
In the other side, developed countries have green technologies, for example, solar technology, and more patents and experience than developing countries. While in developing countries, there are still challenges in food security and climate change. In many developing countries, appreciation of the value of IP rights in creativity in general and sport in particular is fast evolving.
Here we have a case study that shows the strongness of the intellectual property rights in the field of agriculture. We took as an example the name tree, which is an Indian tree that has been long used as a traditional medicine in India. And the name tree was ignored for centuries by the Western world because in the beginning the practices of Indian peasants and doctors not deemed worthy of attention by the majority of British, French, and the Portuguese colonialists. But in 1971, US timber importer Robert Larson observed the tree's usefulness in India and began importing neem seed to his company headquarters in US. And over the next decade, he did a safety and performance tests upon a pesticidal neem extract called the Margozone O. Then in 1985, he received clearance for the product from the US Environmental Protection Agency. And after 3 years, he sold the patent for the product to the American multinational corporation called W.R. Grace & Co. And since that time, more than a dozen US patents have been taken out by US and Japan firms on formulate neem-based solutions and emulsions, and even for a neem toothpaste. But W.R. Grace & Co. Corporation secured in 1992 its right to the formula that used the emulsion from the neem tree seeds to make a powerful pesticide. And it also began suing India companies for making the emulsion. If we move on to talk about protected geographical indications, we can say that agricultural products have qualities that come from their place of production, but also they are influenced by specific local factors such as climate and soil. Here we have some examples about geographical indications in agriculture. For example, the Darjeeling tea, which is the most desirable tea in the world, it is grown in the mountainous regions of northern India. It achieved an international status. The Darjeeling Planter Association was formed in 1892, and the Darjeeling logo is now registered as the certification trademarks of the board under the Trademarks Act of 1999. Another example, the world famous orange of Nagpur, that was given the geographical indicators tag under the Act of 1999. It was registered and protected as well. So this gives the Nagpur orange an edge over other varieties of orange in the markets of the world. Finally, we have the example of Tripura Queen pineapple. According to Tripura, which is a state of India, it becomes specific because of the yellow in hue and the sweetness and aroma that are unique and different from pineapples of other states of the Northeast.
Here we can find some reference where we put the information.
So here the references Thank you for listening.
Thank you for your attention.